Good afternoon, and welcome to the Employer Link webinar series presented by McAfee & Taft. My name is Brad Neese, Managing Editor of Employer Link. Today our topic is social media and the growing challenges facing employers with competing interests between protecting the company brand and safeguarding employees' rights. Our presenters will provide practical advice for mitigating risk, staying out of court, and protecting your company's business and reputation. Our presenters today are McAfee & Taft employment attorneys Charlie Plum and Josh Klein, and intellectual property attorney Zach Oob. Both Charlie and Josh represent employers in all phases of labor and employment law, including before state and federal courts and before regulatory and administrative agencies, as well as in arbitration matters. They counsel employers on compliance with a broad range of state and federal employment laws and regulations, and educate management on best practices for avoiding disputes arising from the employer-employee relationship. Both are also featured speakers and authors on workplace issues. Zach focuses his practice on intellectual property law, including trademarks, copyrights, patents, licensing, unfair competition, internet law, and trade secrets law, as well as the resolution of disputes involving intellectual property assets. He also counsels employers on drafting employment agreements to protect various intellectual property interests. So with those brief introductions, I'll now turn it over to you, Charlie.
Thanks, Brad, and hi, Josh and Zach, and let's get started. Today, we're going to talk about social media, which is pervasive. It touches and affects our lives on a daily basis in a lot of different ways, and that includes our business and our work lives. And one of the things we've noticed lately is with the expanding technology and expanding usage of social media, it seems like weekly we're encountering and our clients are encountering new problems cropping up. The challenge is the problems and technology and usage is expanding so quickly, our laws have not kept pace with these new developments. So today, we're going to talk with Zach, who's going to alert you to challenges businesses are facing when it comes to corporate use of social media. And then we'll turn to Josh, who's going to explain employment issues concerning social media and the workforce. I think the message we hope to get across today is you are best served to anticipate and respond proactively to potential problems when it comes to social media. And that really means having in place an effective and workable social media policy. So we'll close our discussion today with offering some suggestions on what that policy should look like. A good beginning point to today's discussion is some amazing numbers about social media. 96% of 18 to 35-year-olds in America are on one or more form of social media. 96%. And, that 18 to 35-year-old range is the heart of our emerging workforce. Another astonishing figure is U.S. citizens spend 25% of the time they're online using social media. And here's something that I think Zach's going to talk to us a little bit about. 91% utilize social media to search for local businesses or to search for, services that are necessary. So why do employers and businesses use social media? And I think the thing to recognize is today social media is probably the most effective way to stay connected with your public, business partners, including some marketing efforts. So, we're seeing employers and businesses use social media really replaced the yellow pages to find and contact services and individuals. It's being used for advertising and marketing, staying in touch with your customer base, and a way to keep your brand out there and very, very visible. The flip side is employers are periodically going to find themselves in a situation where they may have to monitor or review their own employees' use of social media. Not always pleasant, but necessary in today's work world. And where we see the most common usage or need for employers to monitor employees' social media use are the 5 things you see on our screen there. Number 1, we find employers having a need to search or review employee social media to investigate absences. That is, whether someone's really absent from work on a bona fide basis. their social media may indicate through postings or photographs they aren't actually sick. They may be taking a great vacation for all we know. Number two, we see employers reviewing social media and their employees' use of that social media to address workplace productivity. It's no surprise that in the course of a workday, the modern-day workforce does stay involved, does stay connected with social media, and if they exploit or abuse that access when they should be working, it can impact, obviously, their productivity, their ability to get tasks completed. Number three, hardly a day goes by when we don't face some sort of issue where discrimination and harassment among and between members of the same workforce may be communicated through a form of social media. It used to be emails. Now we're seeing allegations of harassment or discrimination that arise through Facebook postings, Twitter, Instagram, you name it. Number four, employers find themselves monitoring their employees' social media use, perhaps to protect or determine if intentionally or unintentionally confidential business information is being disclosed or leaked. And finally, number five, some of our employers, particularly if they're involved in regulated industries or perhaps publicly traded, may be required to search or review their employees' social media use to see if there is illegal conduct involved. Now, the challenges we face as employers and businesses when it comes to social media are really a product of the characteristics of social media. And that is, number one, it's amazing to me what people will say or what images they will post through social media. People, for whatever reason, they view it as some sort of impersonal communication. They are willing to say things or post images through social media they would never say to you in person. The breadth of distribution, once it's out there, it is very difficult to control information that has been communicated through social media and keep it under wraps. It tends to move very quickly and very broadly, and once it's out there, it's very, very difficult to retract or correct. So these are the kind of characteristics that really complicate both a corporate or business use of social media as well as the kind of employment issues we're dealing with on a day-to-day basis. Now, Zach, bring us up to speed on what's happening when it comes to corporate social media accounts, but start by explaining to us what do you mean by a corporate social media account?
Sure, Charlie. A corporate social media account is an account that's created by a company to promote the company, and it's managed by employees of that company. They're extraordinarily common on social media platforms like Facebook, but they're becoming increasingly common on other social media platforms like Twitter and Pinterest. They're invaluable tools to promote your brand, to advertise to your customers, but they can also create problems for the business, an example of which is on the screen. Widget Inc. Creates a Facebook account. Joe, a recent hire, is asked to manage and set up that account, and he does so by using his personal email account. Well, Joe works for the company for 6 months, and then he's terminated. Angry about his termination after the fact, he doesn't give up that account information to Widget Inc. and begins disparaging Widget Inc. on their own Facebook account.
And explain to our listeners, how does this company, Widget Inc., get in a situation where a departing employee somehow retains control of Widget Inc.'s Facebook account? How does that come about?
Well, that's a really good question. I mean, the thing to keep in mind is that social media is designed for people, not Incs and LLCs. So accounts have to be managed by your employees, and those people may not always be your employees. So when Joe sets up a Facebook account, he types in a personal email, like a Gmail address, and all of the account information about that account goes to the Gmail address. And if the company's not careful, Joe is going to be the only individual holding that information. This is a real-world problem, not a hypothetical. There was a case in 2012 where an employer had to sue a former employee in federal court because that employee took the company's MySpace account and all the customer contact information that was associated with that account to a competitor. So the companies have to adopt policies that dictate, first, how employees use social media, which Josh is going to be talking about a little bit later, and also how corporate accounts are to be created and managed. The first recommendation, which I've already alluded to, is when you create an account, use a company email account. Don't let your employees use a personal account. And I would recommend creating a company email account designed specifically for social media. Store all of the usernames and passwords someplace that can be accessed by management should your social media manager leave. And also choose your social media platforms wisely. You're going to need to manage and watch the content that is placed on your corporate social media accounts. If you have one on every single platform, that just becomes more and more difficult. As far as managing the content on your corporate social media account, limit the access to the account and password information. The recent story about the EPA tweet about the Kim Kardashian app is just a perfect example of too many people having access to social media account passwords and account information because they had an employee inadvertently send an automatically generated tweet to the whole world about Kim Kardashian and her app. So you've got to limit the access to that information, and also choose your social media manager wisely. Usually someone in advertising or in HR, but choose the person who's going to manage the account wisely, someone who's familiar with social media, and someone who is going to be careful about the content put on there.
Well, when you talk about account management, Zach, are you finding that companies and businesses that are active in social media, they have one conduit, in other words, one individual that's responsible for putting information in the social media, or do they allow multiple people to contribute content?
Generally just one. That does depend on the size of the company, but what I've seen is the growing trend is for companies to choose one person to be the face of the company on social media and to manage all those accounts. But the key is for the company to create an effective policy that is at least signed by that individual, but that includes at least a couple of things. First, that the company owns the account. Again, the individual is going to set up the account, but the company policy needs to make clear that that individual doesn't own it, that it's the company's account, and that employee's use of the account is on behalf of the company. I would also recommend putting in, the absolute do's and don'ts of what to post on those social media accounts. Josh is going to talk a little bit later about prohibitions on disparaging and harassing comments on social media. Those things should be included in a corporate social media policy as well. And a system for screening the content. Even if you've got a good social media manager, I would recommend putting in place a system where multiple people, at least two, are looking at what's about to be placed on your social media posts. And most importantly, an acknowledgement that the company owns confidential information and that whoever is going to be using these accounts is going to protect that information.
It's a shock to me that anything involving Kim Kardashian would get out of control. You would think that would just be the soul of reason, that outfit.
I hear the app's a good one. I haven't tried it personally. So here's an example about needing to be careful with your content, especially with proprietary business information. After Joe is terminated, Sally begins to manage the Facebook page at Widget Inc., and she decides to take a picture of some employees hard at work to post on the company page. Behind those employees is a whiteboard with a diagram on Widget's latest work. Well, if Widget wanted to claim that diagram or that product was a trade secret because it wasn't yet disclosed or wasn't yet sold, Sally could have just lost that trade secret for the company. If the product was potentially patentable, Sally's picture posted on Facebook could be a public disclosure of the invention that begins to trigger a 1-year bar on filing a patent. It could also negate the company's ability to file foreign patents. And if Sally was at another business, took a picture of a different company's employees, that picture may give rise to a misappropriation claim.
You know, your example, Sally, is a good one. Many of the trade secret or confidential information disclosures through social media that we're running into are not instances in which an employee or an individual has intentionally tried to disclose or leak confidential information. It's unintentional. The other thing to keep in mind, in addition to trade secrets, if you are a publicly traded operation or business, sometimes information, again, intentionally or unintentionally communicated through social media, can give rise to some, insider trading allegations and the like. So it's something that's very, very important, and we have to be very careful about.
That is correct, Charlie. I mean, the unintended consequences of seemingly innocuous social media activity could be pretty drastic. That's why the right people and processes need to be put in place to monitor what the company puts out there. So the couple of points to make: the content lasts forever, as Charlie noted earlier. You've got to have permission for your posts, especially if you're referencing suppliers or customers of the company. If you're going to be using sweepstakes or some type of contest on your social media pages, there are miscellaneous state and federal laws governing sweepstakes and those sorts of contests that you need to be mindful and cognizant of. And also, every social media platform generally has a content or a contest rules, sort of terms and conditions that you should review before you put a contest on that social media platform.
We're running into a lot of examples where you've probably seen them before. People have an active daily blog, and they are describing or posting their day-to-day activities. And some of those are personal, and some of those are work-related. They're recounting what they did in the way of tasks completed or responsibilities carried out. And those kind of day-in-the-life blogs may inadvertently provide information that is highly confidential.
Right.
The other risk is when you get in a mode of sharing information and activities through social media, and it touches on what you're doing in your job, what you're doing in the course of your day. Sometimes that information is not your employer's information. Sometimes you're sharing information about your employer's customers or your employer's clients. So the other danger there is not just perhaps inadvertently sharing information involving your employer or its plans, but perhaps disclosing some very confidential information that has been entrusted to you and your employer by a client or customer. And then that gets very, very hairy.
And it ultimately comes down to, as you spoke about earlier, how impersonal social media seems to be and how shockingly willing people are with posting a message that they wouldn't otherwise put down in writing or even say, verbally. For instance, I mean, a PR executive at a major corporation was terminated when she tweeted a derogatory joke about AIDS while in flight to a business trip in Africa, and lost her job when she landed. And that's the sort of thing that you've got to be. That's the sort of shocking content that can sometimes come out of social media.
And Zach, I mean, that was on her personal Twitter account, isn't that right?
Yes, it was, Josh.
Yeah. And so, in those situations, you might, as an employer, hear an employee say, "Well, that was on my personal account, and that's my First Amendment right to speak on whatever I want to." But the fact of the matter is, although individuals do have First Amendment right to freedom of speech, it doesn't give you a right to say whatever you want to in the employer-employee relationship. And so, her being terminated for those remarks, was an appropriate course of action, or legally speaking.
Now, Josh and Zach, let me ask you this question. We've been discussing the dangers of disclosing confidential information or trade secrets through social media. Do you find that businesses and employers are devoting time and resources to monitoring what their employees are doing in terms of social media, or does that really only come into play once there's a problem or once a complaint has been brought to their attention?
Well, I can tell you, Charlie, from a corporate social media account perspective, the thing to do is to make sure that the person who's in charge of putting the content on the corporate social media accounts should be the same person who monitors the content going on there by third parties, and you should probably have somebody else monitoring the content being put on there by your social media manager. As far as what's going on employee accounts, I'll let Josh speak to that.
Right. Well, and another thing just to think about in terms of social media is it's like we've discussed already, it's an emerging area, and people seem to believe that social media is a here and now deal, and so they might not be putting in the resources that Zach has mentioned that should be in place to monitor, just because of the, people think, well, if I don't put it up right now, it's not going to be relevant anymore, because that's what social media is. But it's important to take the time or put procedures in place so that can happen quickly, just to make sure that monitoring.
I think, my feel is that, Zach, your monitoring suggestion when it comes to a corporate account makes all the sense in the world and is very practical, because, if they followed your suggestions, it's the business that's controlling that information, it's controlling that social media. But we may have 200 employees who are geographically dispersed, so the ability to monitor each one of those employees' personal social media is limited. I would say, from a real-world perspective, when you're talking about employment issues and personal social media content, it seems like an employer reviewing an employee's personal social media, that usually arises when a problem is brought to our attention. It means, a coworker is concerned or angry and has brought it to a supervisor or HR, or perhaps a customer or client or a member of the public. Josh, what's your experience?
Yeah, no, I think that it's when a major gaffe gets made and it becomes public knowledge. I mean, a person can have a personal Twitter account and maybe have 100, 200 followers. It's when those individuals start retweeting and it becomes a bigger deal than just that one person's tweet that it becomes an issue. And I think the important thing is to include it in your handbook, include it in a social media policy, and educate employees on the front end, what they should and shouldn't be posting. And if you do that, then you can try and avoid those gaps.
Now, Zach, back on this minefield slide we're looking at, you had a point about, you said caution when using or linking to third-party content. What are you getting at there?
Well, there are copyright issues associated with images, music, videos that you put on your social media, as well as a corporate website. Courts generally hold that it's not copyright infringement simply to link to a site that may have some infringing content, but if you link to a site that has infringing content, then that can be a claim of contributory copyright infringement. So, don't willy-nilly just throw up links to posts and other things. Take the time to go through, read it, and investigate it before you throw it on your social media account. I think I already touched on the sweepstakes and lottery law point, where there are miscellaneous laws to keep in mind. One of those is the Children's Online Privacy Protection Act, COPA, which, if you market to children under the age of 13, or could arguably be marketing to children under the age of 13, I would definitely read the Complying with COPA PDF that is in our resources guide that is provided by the Federal Trade Commission. You could also find on their website. With respect to the FTC, they have been aggressively enforcing their FTC regulations and FTC law for social media content and offenses. A definitely recommended read on your Sunday afternoon is the .com disclosures, how to make an effective disclosure in digital advertising.
Is that's the kind of thing you do on the weekend? Is that right?
That's what I'm doing all Sunday, Charlie. This was released in March of last year, but it addresses the various forms of online advertising, gives actual examples of what the FTC would find to be compliant and what the FTC would find not to be compliant with their regulations. Again, it's on the FTC's webpage. You can Google that .com disclosures sentence there, but you can also find it in our resource page after the webinar is concluded. So we've been talking about corporate social media accounts, and Josh is going to be talking about employee social media accounts. There's also the world of third-party social media accounts that could be problematic to your business, namely by being an imposter account, counterfeiting your business. An example of which is on the screen. Joe, upset after being terminated, starts a new Twitter handle at Widget Inc. And acting as if a Widget employee, he begins putting out derogatory comments about others and the company.
You know, your example, Zach, is fascinating, but, is it something we're really seeing happening, these kind of counterfeit or false social media accounts set up? Is that a real problem?
I handle, on at least a monthly basis, counterfeit accounts on all types of social media platforms and infringing content across the spectrum, from Facebook to Twitter, to Instagram, to Pinterest, people who may be, knowingly trying to impersonate a business, and also just using company copyright or trademarks without the authorization of the company.
Well, I get your example where, for some reason, someone's angry about a particular organization or business, and they set up a false or counterfeit social media account to belittle or harm that company. Are there other things you see people doing with false or counterfeit social media platforms, or is it mostly the kind of attack value you've described?
No, it's split 50-50. I have seen strange scenarios where just someone who had no affiliation with the company started a Instagram account acting as if they were the company. Makes no sense whatsoever. They're not necessarily saying anything derogatory about the company on the account, but the risk and threat of that happening is substantial, because to anyone just surfing the internet, that looks like it's a social media account generated and managed by the company.
And one thing, too, to watch out for, particularly with Twitter, is that you can create a fake handle and then change your name to something totally different. And the people who have followed the fake company are now following this totally different company. So that could be a reason why individuals do that.
Yeah, one thing I've run across, I guess falls in the category you're describing, Zach, is an instance where a well-meaning, very loyal employee who loves his or her job and business sets up a social media account really touting and promoting and trying to help this employer and this business that he or she loves. The problem is the outside viewer or follower understands or believes that is a bona fide, official, sanctioned social media communication from the company, which may or may not be okay. That, however well-meaning, the communication may not be what that employer or that business intends or wants.
Right. And you're at the whim of that individual, with some respect, if you do nothing. So, people always ask, what can we do if this happens? Unfortunately, there's no intellectual property, laws out there specific to infringement on social media. You've got to fall back to the traditional concepts of trademark infringement or copyright infringement, trade secret misappropriation, things of that nature. But infringement of trademark or copyright, or squatting, which is creating an account with a known business name and just kind of sitting on it, doing nothing with it, is generally a violation of social media terms and conditions. Your larger social media platforms have these rules prohibiting that sort of behavior, as well as complaint forms that you can submit to the social media entity, basically trying to get that unauthorized use of your company intellectual property taken down, which could result in the whole account being deactivated, being transferred to the business, or just that content being taken off specifically. We've included links to some of the major ones: Facebook, YouTube, Pinterest, and Twitter. If it's a different platform, you can generally just Google, social media account complaint form. Now, all of the social media platform terms and conditions are going to say that it's their sole discretion to determine what's infringing and what to take down and how to react. So you are, to some extent, at the whim of the social media provider with how quickly they're going to react and whether they're going to take it down. And every single provider is different. I've gotten a different reaction from Facebook that I have from Twitter, from Pinterest, and from YouTube. So it's my recommendation is if you see something that is concerning, jump on it quickly, contact the social media provider, and follow up with them as needed.
Jack, if I'm a business and I've discovered some infringement or unlawful use of my information through social media, and I go to Facebook and I follow your instructions, I move quickly and want to get that resolved, want to get that information, that communication taken down and ended, but they're not moving nearly as quickly. I mean, do I have any claim or right as against Facebook, or am I just twisting there out in the wind?
Yeah, the liability of the social media provider is not entirely settled in the law, but there are a lot of cases which hold that they're just really a conduit for the content. They don't have necessarily the duty to take anything down. Google specifically has won a lot of cases in this respect. So you really don't have a whole lot of recourse against the social media provider. There could be a colorable claim of some sort of contributory infringement, but the real claim is going to be against the infringer. And unfortunately, in the realm of social media, you may not know who that person is. A Twitter handle may not give you their address to serve a subpoena on them, their name to list as a defendant in a lawsuit. And so it can be a really tricky situation. There are also ways that you can privately contact other account holders on different social media platforms, and that may be something else that you attempt to do if you get no feedback from the social media provider. Send what would otherwise be a cease and desist demand through the social media provider itself, not by letter, because you may not have their address.
Again, I think a good point you make is it puts a premium on monitoring and acting quickly if you see a problem. In your experience, Zach, how do I, as a business, first discover I got a problem, some sort of infringing or wrongful communication through social media?
Well, you can.
How does that brought to my attention, I guess, is what I'm saying, as a practical matter?
You really got to have someone who monitors your brand on the Internet. If you Google your brand name, and if there's a Twitter account or a Pinterest account or something like that associated with it, generally it'll pop up. You could set up a periodic check of different social media platforms to see if someone's infringing. I mean, what I've encountered is the companies who've got an established policy do have an established process of a periodic check of their brand on social media and on the Internet. And that's how they spot these issues so they can jump on them quickly. And it ultimately can become a business decision of what you really want to fight. If it's egregious enough, you'll put in the time and resources to try to find that person, file a lawsuit. Sometimes it's not, and if the social media provider doesn't do anything about it, it may not be worth your time and expense in going any further.
All right. Well, that's a good lesson, good suggestions. We're going to switch now a little bit to the employment context, and Josh is going to bring us up to speed on what's going on in the employment world when it comes to social media. Also provide some suggestions. But one thing we want to make sure everyone realizes, particularly when it involves employment issues, you often hear thrown around when we're talking about a social media issue or reviewing someone's social media, this question of privacy or intrusion. keep in mind that generally, if information is publicly available and publicly accessible, there is no right of privacy. And you're going to hear that as a theme throughout Josh's subject matter. But, there are different levels of privacy you can use and access when it comes to social media. But, as a general rule, Josh, if I can access information through social media, it's not private. Is that correct?
No, I would agree with that, Charlie. I think if it's available to you and you can see it out there without having to have the user access it for you, that's public. That's public information.
Okay. And so get us started. I guess the starting point of employment is what's happening in your experience when it comes to social media and the hiring or vetting process of candidates or applicants.
Sure. And as more people get on social media, I think we're finding more employers utilizing a search of social media to find out more about the candidates, whether it be on Facebook, kind of where everything is put in a regimented manner, or Twitter, where kind of people's, instantaneous thoughts get put out there. And it can provide you with a lot of information that's negative, regarding a candidate's judgment, for example. People have lapses when they post pictures or when they post certain thoughts online, and those ideals might not conform with your company's core set of values.
But you're thinking my posted pictures of college spring break is not going to be positive in my job search efforts. Is that what you're suggesting?
They're good pictures, though.
Okay.
Yeah, they might not be, Charlie. I don't know. I'm not sure what occurred during your spring break, but it might be something of interest to an individual conducting hiring. But you can also learn positive information. It's not just the negative. It's not just the pictures and whatnot. It's also some things that may not have come up during your interview that the candidate didn't have an opportunity to express. Service they do in the community, or other positive aspects of their life that just didn't have an opportunity to come up and let that candidate shine. So, searching that publicly available information is okay, with a caveat that we'll talk about a little later.
A number of the employers we work with will use a social media search as an effort to see whether someone's resume or the things they've been told in the course of an interview are true. In other words, see if there's some inconsistencies in a description of experience, or perhaps inconsistencies in education background, and they'll check social media for that purpose. Have you run into that as well?
Yeah, I have, and I think that that certainly makes sense to do, to double check your resources in an easy to do manner. So that's certainly something we've run into, and certainly something that seems to be a good idea.
So as long as I'm using social media information that is public and readily accessible, that's kosher, right?
Yes, as long as it's not, and that comes with a caveat. There's a new Oklahoma law that's going into effect in November of this year, and what it does is it makes it illegal for employers to require a prospective employee, as we just talked about in the hiring process, but also a current employee, to hand over their username and passwords so that the employer can access private social media content. And by private social media content, we're talking about if the user has put up privacy settings on their account. For example, Facebook is a great example. You can have certain information that's available to the general public, but make other information available only to your friends or only to the people you select. And if the hiring person, or if your manager, if your current employee is not one of those people you've selected, you cannot require, starting in November, the employee to hand over your social media passwords and usernames.
Okay, let me ask you two questions about this law that's going to go into effect November 1. Incidentally, we're not advising an employer force an employee or candidate to give passwords or private access up before November 1 anyways, are we?
No, I think it would have been a poor practice beforehand, and this law is just the legislature's attempt to catch up to what's really happening out there.
Two questions then, Josh. Number one, let's say I have a password-protected social media, and I'm an existing employee, and you're my supervisor. You don't ask me for my password or for access. You simply come into my office or come to my desk and say, Charlie, I want you to bring up your Facebook page, including the non-public portion of it. Is that going to be lawful under the statute?
Well, Charlie, you're thinking a step ahead here, but in terms of trying to avoid the law, but the law specifically makes it clear, no, you cannot do that. You can't, work around the system by asking the person to put it in the computer and you look over their shoulder at the content.
Okay, now here's a question too, and I don't know if there's an answer to this. I've got a privacy protected portion of my Facebook. You're my supervisor. You haven't asked for for any access, but Josh, who does have access, brings to you unsolicited, information on that private setting or those private postings. Can you use that information or not with this new statute?
Right, and I think the statute is silent to that particular kind of activity, to where a coworker who might have access to that setting, assuming he didn't do any of the things outlawed by the statute, I think that's fair game. That has been publicly made available, or at least made available to your coworker.
You haven't solicited it.
I haven't solicited it.
Okay.
I haven't asked anybody for the username and password, and so that would I believe to be fair game. Of course, the law hasn't gone into effect yet, and we haven't seen any ramifications. So, the other thing at the hiring stage that we talk about is complying with anti-discrimination statutes. Now, we've talked about the wealth of information that's available. Some of it can be good judgment, some of it can be poor judgment. But what you can't do is utilize information regarding an individual's religion, disability, national origin, or other protected characteristic. You have access to that information on social media, but again, you can't use it. You wouldn't ask those kinds of questions in an interview, and you should not utilize them on social media.
And what give our listeners, Josh, some examples of what sort of information do employers unintentionally sometimes run across when they're looking at social media about a candidate or an applicant? Because, a lot of people share very personal information on those sites.
Right, and I think one of those characteristics that's not obvious or something in an interview situation would be something about an individual's religion or certain religious beliefs they may hold, and they may belong to a group of like-minded individuals, and you may be able to see that on Facebook. You certainly wouldn't ask about that during an interview, and you should not utilize that information when making a decision to hire an employee or retain an employee.
And we've seen instances in which individuals that we're considering for employment are sharing private information like what their family plans are, if they're intending to have children or how soon they're having children. And that'll be included in some of their personal postings. And again, like your religion example, Josh, we're not supposed to be asking our candidates or our applicants, hey, when are you going to have kids and how many of them? But we may stumble upon that, right?
Yeah, and I think that's why it's important, Charlie, to have safeguards at the work, when reviewing this information, especially at the hiring stage. I think one example may be to have a kind of a dual system where you have one individual who's tasked with researching the social media and mining that information to come up with what may be relevant in the hiring decision, and then having the decision maker review a report made by the searching person. And that will allow you to two benefits to that system. One is that you're not allowing the decision maker to review any information that would be unpermissible. But the second is you're creating a written record of the information you did utilize. In the case that an unsuccessful applicant becomes litigious, you have a record of that they didn't review that information.
One of the big struggles I see now is instances in which we're all increasingly sophisticated in our use and familiarity with social media, where we're in a hiring situation, and many supervisors may just off on their own, just kind of do some freelance social media search. And that's one thing we want to tell our supervisors, that we don't want you doing that when it comes to our candidates and applicants.
Yeah, I agree. You don't want to go rogue from your policy and just start doing your own research, because, like I said, nothing good can come of that. And so now that we've talked about the hiring stage, what kind of issues come up during employment? First of all, whose time is it? And although the first point on here says there's nothing wrong with restricting social media access on company equipment, I think it's important to understand this has become so pervasive that it really becomes important to use good judgment. We can't discipline or fire everybody who uses social media during work. Otherwise, with the way things are now, you might not have any employees left over at the end of the day. And so it becomes important to be smart and take things on a case-by-case basis. If the person won't get off Facebook to take her supervisor's call, that may be a bigger issue than just a quick Twitter status update about, an Ohio State football game during a brief moment of downtime.
And Ohio State, you're talking about America's team.
In the eyes of some, Charlie.
But, the analogy I would give, it wasn't too long ago, maybe 15 years ago when Zach and Josh were 11, that employers used to have, if you can believe this, a no cell phone rule. No, you were absolutely prohibited. That's when cell phones were just getting smaller, getting more sophisticated, and more common in the workplace. And it became very apparent quickly that absolute ban was just not going to work, and it's better to control on a case by case basis when somebody's abusing that. That's really what you're advocating, right?
Yeah, right. I'm not suggesting that we have becomes the wild, wild west out there, but I think that, you make sure that you understand that, just like cell phones have become a part of society that everyone has, social media is too. And so, and that kind of brings us to the next idea, bring your own device. A lot of employers are becoming more and more receptive to, instead of providing their employees with cell phones, smartphones that they can do email with the fact that smartphones are becoming increasingly used for personal use, just combine the device, allow the individual to bring their own cell phone into work, allow them to upload or download software for the company, and use that device for work as well. In a sense, bring your personal phone into work and do work functions on it. There's a couple of issues with this, though. The first is kind of, in some regards, a loss of control. And just to use as an example, the Oklahoma law that just got passed allows an employer to search their own system for certain information, but has stricter prohibitions on the search of a personal device. And so, you do lose some control on the amount of access you have to the device when you're entrusting the employee to bring their own. And the other issue is that it not only gives employees access to their personal life at work, but also access to their work during their personal time. It's important that if you're giving employees access to work at home, if they're overtime eligible, you need to be making sure you have procedures in place to make sure that they're properly calculating their time working outside of the physical workplace.
As a practical matter, I just think we're going to see more and more acceptance of individuals using their own devices, including when it comes to business responsibilities or job responsibilities. One thing that I've seen employers do that I think makes a lot of sense because of the issues you're talking about, Josh, is having a policy in place that lets employees know whether and how they can use their own devices when it comes to business information and business responsibilities and tasks, staying connected, but also having them acknowledge if they choose to use their own device, they're going to have to approve and authorize it and acknowledge that they have no expectation of privacy. In other words, that same line gets blurred in their lives as well. You can't use a device, a personal device, frequently and freely for purposes of business, and then claim that you still retain some sort of personal privacy over that information. Sure. What about you have online harassment? What are you seeing these days when it comes to harassment?
Well, I mean, you look at the scenario that's posted on the slide here, and John is making sexually suggestive comments via direct message on Twitter. And for those of you who aren't is Twitter savvy, that's a message from one person to the other, and the public can't see that message. Susan receives these online communications both during work and after work hours, and she complains to management. It's important. This situation needs to be investigated by management. First of all, she's receiving these messages during work hours, so it's obviously something that's occurring at the workplace. But even if they were all after work, it's still something that ought to be investigated by management. The Oklahoma law allows you to actually request the username and password of an employee to investigate compliance with the law. And in this case, that would be Title VII. You have the ability to investigate. So, in that case, you can ask for the password. But what happens when John says, no, I'm not going to give you that information, no matter what you say? Well, I would explain to John that you need to continue, that you will have to continue with the investigation, but if the access is not allowed, you'll have to assume that the allegations of the direct messages are true. And this is important because, you have an obligation as an employer to investigate instances of harassment. And although you have to investigate them when they occur on work time, it doesn't make sense to draw a delineation and not investigate it off work time.
One thing that sometimes gets lost in the shuffle, no matter how advanced and sophisticated social media becomes, it is simply an alternative form of communication. So whether we're talking about hiring or harassment or what I'm doing in the course of my workday, if the communication would be impermissible or unlawful or unprofessional or inappropriate if I said it to you over the coffee pot, or if I said it to you in the parking lot, or I said it to you at happy hour, or I sent it to you in email, the fact that communication comes via Twitter or Instagram doesn't change those issues, does it?
No, it doesn't. It's really an extension of the water cooler conversation, and this comes back to, and it also involves workplace complaints. And I do want to bring up quickly that employees have a right to discuss wages, terms and conditions of employment, and their supervisors and things of that nature in the workplace. And traditionally, those have come in face-to-face conversations, but with social media, now those conversations can occur online, and not just privately in messages, but also publicly on Facebook.
You're talking about when I've had a bad day with my supervisor, or I think I'm underpaid, or I feel like I'm getting jerked around by my employer.
Right. Yeah. You have the right under federal law to discuss that amongst other employees, those issues and those complaints. And the federal government has interpreted these rights so broadly now in favor of the employee that Facebook posts with comments is equivalent to a Facebook face-to-face conversation.
And that becomes a situation that's problematic if the company has a social media account, has a Facebook account, and you've got employees going on the company account that you've created to advertise with the company and complaining about the employment conditions of the company. As a function of Facebook, you've got the right to take that down. But that may not be in compliance with employment law, and it also may not be a good PR decision because, frankly, the company could look like they're trying to cover something up, and so that's when the company's faced with with the business decision of what do you do in that situation.
Well, if you go to our own blog, Employer Link, you'll find it does not accept comments. Right, exactly what you're saying, Zach, is, there's a potential loss of control. And I know this is going to be shocking to our listeners, but every now and then people want to say bad things about attorneys. I mean, it's a shock, right? But that's a decision we made in terms of controlling our own social media at McAfee and Taft.
And you know, I deal with this on a routine basis, where an employer will ask, you know, what can I do? This company is saying that one of our managers is sexually harassing them, or that they're engaging in discriminatory practices, or they're just generally complaining about the employment conditions. Well, you know, and I will tell them it, you know, depending on the message, you may not be able to take it down, and what may be the best move for the company is to respond by saying, you know, we take these allegations seriously and we will look into it immediately, and then doing so pursuant to your company policy. And that's where your advertising and your social media image can sometimes collide with employment concerns and your rights as the owner of the social media account itself.
You know, Josh, to your point about the crackdown we're seeing against employers and how they may be trying to control or punish employees about social media communication, you know, I see that coming up two ways. Sometimes they are challenging an employer's social media policy as too broad and saying, look, these restrictions that the employer's policies set out on what you can and can't do on social media are such that it just puts a lid on any communication. I'm also seeing situations in which an employer has a social media policy in effect, an employee violates that policy, and they're fired for it. And so then the labor board will come in, and this applies whether you're union or non-union. The labor board will come in and challenge legally that firing and saying that was also violative of the employee's rights to comment, and an employee can't be fired for communicating some dissatisfaction through social media, much as they couldn't in the break room.
And along those lines, too, something that Zach said a minute ago, but people complaining maybe on a Facebook account of being sexually harassed or whatnot. I mean, you have to be very wary of taking negative action as to avoid a retaliation claim.
Yeah, and here's the practical approach. Again, no two situations or circumstances are exactly the same. You're going to have to make those decisions on a case-by-case basis. And, you know, there are some instances in which an employee's conduct or behavior is so harmful or so extreme or so inappropriate, you're going to be justified in taking action based on their social media communication. Sometimes it may be a little bit riskier, but, you know, our goal really is to really give you a heads up on what sort of curveballs you may be facing. Before we get to our kind of wrap up with recommendations for components of a good corporate social media policy and a good employment social media policy, I'd like to share another development recently. You know, it wasn't too long ago where complaints about workplace conditions, you know, whether it was no overtime or an unsafe work environment, those were communicated to regulatory agencies through an 800 number or through a visit to their office. One of the recent developments, I'd say the last 6 to 18 months, more and more we're seeing members of the workforce complain about those types of practices or making those kind of accusations, not through a call on the 800 number, not through a visit to the Wage and Hour Division, but they're putting it out there through social media posting. So that's, again, back to our point that it's just a form of communication. It's a more effective, you know, better broadcast, but think of it as you have to address it like you would any other sort of complaint. So let's close, and Zach, if you'll walk through kind of the high points of what you think a good policy when it comes to corporate social media accounts should embrace or should cover.
Sure. Make sure that in any effective policy addressing a company-owned account is going to state explicitly that the company owns the account. even though the employees are the ones who are actually putting the content out there and managing the account. There's got to be some parameters on content and limitations on access, and acknowledgement and that the company has protected information, and that the employees using the corporate social media accounts will protect that confidential proprietary information. A system to screen the content, and then not even in the policy. You could put it in the policy if you'd like, but just as a rule of thumb, don't use personalized emails, and make sure that the account manager can be easily passed off. The two overarching messages is first, never assume that the content is private or limited, and secondly, don't combine the issues of your corporate policy with employees' individual policies, because they have separate and distinct issues relating to them, and so they deserve separate and distinct policy.
Zach, that's very helpful, and I think really captured. Okay, Josh, same thing. Tell our listeners what you recommend should be included in a social media policy when it comes to employment issues.
Sure, and I think just as an overarching matter, it's important to be precise in your wording. As Charlie mentioned, the federal government takes issue with overly broad policies, so it's important to be very specific in what types of activity you are prohibiting, if you prohibit any social media activity. And I think one that needs to be in any policy is to just clarify that any harassment that occurs online between employees or by an employee to customers or is not allowed. Just to make it specifically clear that that's not going to be tolerated. Another is just specific limitations on the disclosure of data. This is kind of what I talked about earlier regarding splitting up the duties, or coming up with a policy to make sure that at the hiring stage that the decision maker doesn't have access to the protected activity, the types of information you wouldn't ask for in an interview. And we talked a little bit also about the restrictions on the use of social media during work time, with the caveat, of course, that you're not going to be able to crack down on every use, and you need to be smart, and you need to take things on a case-by-case basis. So I think those are the important things that we talked about today.
That's a great checklist. This weekend, Zach will be reviewing the Federal Trade Commission's suggestions on disclosures on how to make effective digital advertising. In graphic contrast, I will be following the Kardashian social media sites religiously. We want to thank you for your time. We hope this has been helpful. Again, we've tried to approach this in a very practical sense and provide you with some practical suggestions. Hope you can put them to use to your benefit.
I want to thank Charlie Plum, Josh Klein, and Zach Oob for presenting today's webinar. And on behalf of the law firm of McAfee & Taft, thank you for joining us for another Employer Link webinar. See you next time, and have a great afternoon.